Hello everybody, my name is Justin Stivers. I'm the owner of the Probate Law Firm based out of Miami, but we're operating in about 17 counties throughout the state of Florida. So this video is a condensed version of the course I teach called Probate 101 for Realtors. Generally it's a 2-hour course and those in attendance get continuing education credit, but this version I'm going to try to keep 30-40 minutes max, and just kind of highlight some of the must-know things about probate that I teach in the other course. So before I talk a little bit about the course, let me just give you a quick background on me. Again, my name is Justin Stivers. I am the owner of a law firm called the Probate Law Firm, and we do, as you could guess, probate. So what we do basically is we help people while they are still alive. We write their wills and their trusts, and then after people pass away, we do a process that's called probate. And so I started doing this course, depending when you're watching this, about a year ago, maybe a little bit more, because in Florida, especially here in South Florida, I've been noticing that probate is coming up a lot more frequently, and a lot of realtors, both seasoned realtors and brand new realtors, are finding themselves in some sort of probate transaction, either on the buyer side or on the seller side. And so this course is really geared at those realtors who maybe have never dealt with probate before, or maybe just have some questions about it, because we're going to keep it very basic. But again, I just noticed that a lot of realtors are coming into probate properties, and so there's kind of just a lot of confusion out there. And so anyways, that's a little bit about us. You can find more about the Probate Law Firm at www.probatefirm.com. Our office number is 305-456-3255. Again, 305-456-3255. And you can email me personally, justin@probatefirm.com, justin@probatefirm.com. So that's a little bit about us. Again, that's all we do, probate estate planning. And this course, Probate 101 for Realtors, is really 3 goals that I have. I want to help you all know when a property is going to go through probate, so that you can identify it and kind of be prepared for it, and know in the very beginning that yes, this is likely going to be a property that has to go through probate. Help you all speak with your prospective client so that when you go in there for a listing presentation, you stand out, because there's no shortage of realtors, just like there's no shortage of attorneys, but there's no shortage of realtors. And so I think just by being able to speak the probate language, being able to use some of the key words and definitions appropriately, explain to them a little bit about the process, I really think is going to help you all stand out from a lot of your competition. There's no substitution for knowledge. There's no substitution for educating yourself. So I think this will be very, very useful and practical when you're out there. And then lastly, there are a couple ideas that I can give you for marketing for probate properties, probate listings, and so we'll talk a little bit about that. But those are the 3 main points. Again, this course is normally live, and so it's more interactive. I'm going to try to make it as exciting as I possibly can. But again, if you have more questions, send me an email or just be on the lookout. I do this course a lot with the Miami Association of Realtors, and so check out their website to see if there's an event coming up. But basically, just to start, I think probably the best place is to start with some key definitions, some key things that I think you all need to know. And we'll just start with the basics. So what is probate? You might not have ever heard that term before. You might have some idea of what it is, but let me just kind of explain to you, how I view probate, what I think it is. Probate, like I said a couple minutes ago, is different from what we call estate planning. That's a legal term. Estate planning really refers to when somebody is still alive. So that refers to writing a will, writing a trust, writing a power of attorney, and some other things that we do. That's all part of what we would call estate planning. Probate, in order for there to actually be a probate, somebody has to have died. There had to have been a death. That's unfortunately what kind of triggers the probate process. And what probate actually is we are taking whatever somebody owned while they were alive. And so in this case, since I'm assuming most of you all are realtors or in the real estate space in some way, we're taking their property. So let's say John Smith owned a piece of property. He owned 123 Main Street, okay, and that was in John's name. Well, John, when he dies, he doesn't own that property anymore. So in order for his kids or for his, whoever he left that property to, his beneficiaries or whatnot, in order for them to be able to take ownership of that property, to own it, to sell it, to rent it, to live in it, they've got to do what's called a probate process, to do what's called a probate, right? The process is called probate. They have to go to court. They probably are going to have to hire an attorney. They're going to be in front of a judge. And at the end of that probate process, the judge is now going to say, okay, you, the children or whoever, are now the owners of the property. Now you can sell it, you can do with it whatever you want. So when we're talking about probate, what we're really doing is somebody has passed away. We open a case with the court, we go through the entire process, and at the end of it, the judge, the court, is going to say who owns what. So whenever you think of probate, unfortunately someone has died and there's going to be a court process, a court and a judge involved, and most likely an attorney. So that's generally what probate is. An estate, okay, so I've used that word, E-S-T-A-T-E, estate. That's basically how we refer to everything that a person owned after they passed away. So again, thinking of John Smith as an example. So John, when he was alive, he owned his house, he owned a boat, he owned a car, he had money in the bank, all of that. We refer to all of that as John's stuff, essentially. When John dies, he's not alive anymore, so we can't really refer to him as John anymore. What we would do is we would refer to everything that he owned, so all of that stuff that I just mentioned would be called the estate of John Smith. So the estate includes everything that a person owned. It also includes their what we call liabilities. So if John owed any money to Visa, to American Express, anything like that, we would refer to those liabilities as his estate as well. Probably the most important definition and term that you all need to know is called personal representative. Some states might use the word executor. We in Florida use the word personal representative. I'm probably going to say personal representative, and I'm also going to say PR for short, just because I'm going to have to say it a lot during these next 20 or 30 minutes or so, and it just gets a little tiring. So PR, personal representative, that's the person authorized by the court allowing you, the realtor, to sell the property. So the PR, it's very important to know. The PR is appointed by the court. Sometimes a person will have a will. And so what a will is, I'm sure you're familiar, a last will and testament, but a will is a piece of paper written by a person, written by an attorney, that says who's going to get what of somebody's stuff. And in the will, it's probably going to name somebody as a personal representative. That's pretty standard. So usually, just as an example, let's just say the dad had a will. In his will, he's probably going to name somebody as his personal representative. Well, if that person comes to you and they show you the will and they say, look, my dad died, he named me as the PR, that unfortunately is not good enough. We've got to we, the attorney, has actually got to take that will, go to the courthouse, go to the judge in that probate process, and the judge has to say that it is a valid will and has to actually sign a piece of paper called Order Appointing Personal Representative, has to actually sign that, and then that person becomes the personal representative. So I've seen a lot of times where a client will come to me or go to the realtor and they'll say, look, my dad died, he named me as the PR, I'm the only child, everything's going to go to me, et cetera, et cetera. Well, all of that might be true, but we still have to go through the court process and have the judge sign the order appointing personal representative. And for you, the realtor, it's very, very important that you know you cannot list the property, you can't market the property, don't put it on the MLS, don't put yard signs, don't put door hangers, anything like that. You can't do anything until that person becomes the personal representative. So that's a big, big, big error that I see, where a lot of people, they think that the person's going to be the personal representative, and they go ahead and they start marketing it and they do all this work. And what happens is, one, they could get in trouble, but two, there might be someone else who actually becomes the personal representative, and then they don't end up working with the right person, and then the personal representative hires or finds another realtor, and you've wasted all this time. So very important, the PR, that's the person who's going to sign the listing agreement, who's going to sign the as-is contract, who's going to do all of the signings at closing, who's going to pick the realtor, most likely. So that's the person that you need to be working with if you're working on the seller's side. Obviously, if you're on the buyer side as well, but this is really talking about from the seller side. And I talked a little bit about what a will is, and a beneficiary or an heir is just basically somebody who's going to receive something, someone who's going to inherit something. Okay, so those are some of the main definitions I think that you all should know, and just having, be familiar with them, have a working knowledge of them, working definition of them, so that if you're speaking with a prospective client, again, you can sound a little bit more informed, and you will actually be a little bit more informed. So when is probate necessary? Because it's not necessary all the time. It's not necessary in every single instance that a probate is going to happen, right? So your job in the very beginning, and this is coming from an example of, let's say that you don't know, right? So you're not sure if probate's going to be necessary. Now, obviously, I highly discourage you not to do anything that would be close to practicing law, get your attorney involved, but you can kind of have an idea of whether or not probate will be necessary. So let's say, the easiest example is, let's say that you get a call from a friend, and the friend says, hey, my mom just died, I want to sell her property. Well, probate by its nature means that somebody has died, right? So the fact that you're getting told someone has died and someone else wants to sell their property, that's a pretty good indication that probate might be necessary, right? A death is a general indicator that probate's going to be necessary. But that might not happen all the time, right? So that might not be the case. So how can you look it up? Well, the easiest way is looking at the Property Appraiser's website. So whenever you go to look up a property, so let's say someone calls you and says, hey, Justin, I've got this property, 123 Main Street, I want to sell it. Well, you as the realtor, even me as the attorney, I would go look and see who actually owns 123 Main Street. So you're going to go look at the Property Appraiser's website and see who the owner is. And if it's got my name on there, okay, great. Chances are, or it's got the person you're speaking with, it's got their name on there, okay, great. Chances are they're able to sell it. But in probate, or when a person dies, a lot of times the property appraiser is going to update that website, that owner, and they're going to put EST of after their name. So the EST stands for estate of. So if you go and you look at 123 Main Street and it says John Smith, and then after John Smith's name it says EST of, there's about a 99.9% chance that that property is going to have to go through probate before it can be sold. Now the probate might already be started, and the only way that you would really know that is if you went to the clerk of courts, the court website, and tried to search by his name and did some research, which is a little bit tough to do. But so the probate might already be open. However, if you see that EST of, that means that that property is owned by the person who passed away. And the only way that property can be sold is by going through that probate process where, like I said before, a PR is appointed, and at the end of it, the judge is going to say who the owner of the property is. So that's the easiest way. Now, I get asked all the time when I do this, how do we know, or how does the county know when the owner of the property has going to pass away? Well, the government organization, the Florida organization entity that records death certificates, is called Vital Statistics. We've called them, and they say that when someone dies, they will send the death certificate or notify the county where the person owned property, and then the county updates it. However, I've seen records where a person died, 10, 15, 20 years ago even, and the county hasn't updated it. So I don't know that that's 100% accurate. So the truth is, I'm not really sure. Sometimes people will go in to the county themselves. And so this is very common where, let's say mom and daughter are living in the same house. Mom owns the property. Mom dies. Well, what happens? Daughter wants to get the property in her name because she wants to get the homestead exemption, right? So homestead in Florida is essentially a tax benefit you get for your primary residence. And so she goes to the county and she tells the county, hey, look, my mom died, I want to get the homestead exemption. Well, the county is going to say, unfortunately, your mom died, you are not the owner, now you're going to lose the homestead exemption, go get a probate attorney and go through the probate process. So that's sometimes how they update it. So I can't give you a 100% answer when they always update it, again, because I've seen it a couple different times. I've seen it where it hasn't been recorded for a long time, or I've seen it updated right away. But for purposes of right now, if you see that EST of, chances are probate's going to be necessary. Take a drink of water. Okay, so the second common thing that you'll see in Florida is you'll see two owners own a piece of property together, right? So you'll see an example I use is this piece of property that was owned by Jesus Silva and Maida Silva. And Jesus was the father, Maida the daughter. This was an investment property, a duplex that they owned together. Jesus died several years ago. The county updated his record, the property appraiser record, to say Jesus Silva, EST of. Okay, so it had that EST of. Maida still owned the property. Maida decides she wants to sell the property. So she gets a realtor, the realtor lists the property, they go through the entire process, they go to the closing table, and the title agent says, did you do a probate for Jesus? And Maida says, no, we're both on title, he wasn't married, I'm his only daughter, it's my property. And the title company says, well, that might be true, but you're going to have to do a probate for Jesus. And so this happens a lot where people own a piece of property together. Maybe it was an investment property. Maybe if it, for whatever reason, the parents and the child is on title together. Maybe it's brothers and sisters. And the way that they own this piece of property was by what's called tenants in common. And so what that means is essentially Jesus owned 50% and Maida owned 50%. When Jesus died, his 50% did not automatically pass to Maida. Similarly, if Maida had passed away, her 50% would not have passed to Jesus. And so when you have a piece of property like that, when one of the owner passes away, a probate is necessary. And so for this case, what the realtor failed to do was she maybe didn't look at the title, I'm guessing. Maybe she didn't know probate was necessary. Had she looked at the property appraiser website, she would have seen that EST of after Jesus's name, and would have, should have known that probate would have been necessary. But anyways, I think she just got excited. She saw a good listing and went and essentially wasted 4 months marketing this property, and then we had to do the probate as well. So when you see two owners and you know that one of them has passed away, at that point, we need to be looking at title. We need to know how they own the property, because probate might not be necessary, but in this case it was. And again, I would encourage you, bring in your title team, your real estate attorney, whoever. Maybe we order a title report just to see how title was actually held. So in that case, probate was necessary. Now, they could have avoided it, and so probate, like I said a few minutes ago, is not always necessary. Sometimes we can, and really we should, avoid probate. One of the easiest ways to avoid probate is by changing the title itself. Okay, so tenants in common, like I just mentioned a second ago, is a way that you own the property 50-50, but when the owner dies, his or her 50% does not automatically go to the surviving person. Joint tenants with right of survivorship, that's a way people can own property, and the property does pass to the surviving person. So most commonly, you'll see, maybe a mom and dad and their son, or dad and the son, okay? And it will say, John Smith, a married man, and Justin Smith, a single man, and after that, it's going to say with joint tenants and right of survivorship, with joint tenants of right of survivorship, or something to that effect. But it's got to have specific language on that deed. And when you have that language, probate's not necessary. So then in that instance, if I passed away, John Smith, my father, who's not named John, but my father would have to do a probate for me in order to get that property put in his name, to get my 50% put in his name. So if you have that designation, and again, that's by looking at the deed, the property appraiser may have that designation on the where it shows the owner on property.gov, property, whatever the website is, but you probably are going to have to dig a little bit deeper and look at the deed itself, and it's going to have language on there. So if you have that joint tenants with right of survivorship language, probate's not necessary. Husband and wife, generally probate's not necessary. You don't have to have that language, joint tenants with right of survivorship. They actually have a specific designation called tenants in the entirety, which basically just means same thing. If husband passes away, wife gets it. If wife passes away, husband gets it. And the probate is not necessary. Now, one thing to be aware of is if there was a property that was owned prior to the marriage and only one of the spouses is on there, probate might be necessary, but that's a little bit more complicated, and I don't have time to explain that here. But generally, husband and wife on a piece of property, that's going to avoid probate. And then one other quick way that probate can be avoided with title is either a life estate deed or an enhanced life estate deed called a Ladybird Deed. And I don't have time to get into those too much here, but basically what that is again, you can put somebody on title, right? So if I want to put my son on title, but I don't want him necessarily to be a joint owner for a variety of reasons, so I can say Justin Stivers owns the property. When Justin Stivers dies, his son, so-and-so, as of recording this, I don't have a son, will receive the property. So that's another way, again, that's a little bit more complex, and I don't have time here. I see we're already at 23 minutes, man, time goes by quick. So enhanced life estate deed and a life estate deed, or the enhanced one is called a Ladybird Deed, is another option, a way of changing title to avoid probate. Lastly, probably another, I won't say easy, but another way that probate can be avoided, it is easy if it's done properly, is by setting up what's called a trust. So you might have heard of a revocable trust, a revocable living trust, an irrevocable trust, a lot of different names for somewhat meaning the same thing, but I'm just going to call it a trust. And a trust is a way that you own property, and it can avoid the probate process. So it's like a will. A will, again, I talked about a few minutes ago, which says who gets what of your stuff after you pass away. A trust does the same thing. However, a will does not avoid probate, and that's a huge misconception out there. So having a will does not avoid probate. Having a trust can avoid probate if done correctly. So when it comes to property, what we're going to do is we're going to first create the document. So I'm going to first create the actual document that's called a trust, right? And that's got all the legal stuff in there, says who's going to get the property and all of that. That's step number one. Step number 2 is I've actually got to transfer title from the property and make the owner of the property the trust. So let's say that I, Justin Stivers, own 123 Main Street individually, but I want to put the property in a trust so that it avoids probate. So I create the trust document, and in the trust I say that my son, John, is going to get the property when I die. Great. Step number 1, I created the trust. I now have to do a deed from myself individually to make the trust the owner of the property. So I would probably do some sort of quitclaim deed, and I would deed the property from Justin Stivers individually, and I would make the Justin Stivers trust the owner of the property. That way, when I die, my son can just go to the, get an attorney or go to the county, and he would be able to update the owner, and he would become owner automatically. Where I see a lot of people fail is they don't actually take that second step of doing the deed and transferring the property. So that's a huge thing. And if you don't do that, then the trust is essentially worthless, and you're not going to avoid probate. So make sure that you are, if you're going to do a trust, I highly recommend you use an attorney for it, and make sure that he or she does that next step of actually transferring the property into the name of the trust and making the trust the owner of the property. So those are some ways that you can avoid probate: changing the title, doing a trust. And those are the ways that you can avoid probate, that you can identify whether or not probate's necessary, is by looking at the designation. If it says estate of, that's probably a good indication that probate's going to be necessary for that property. Okay, so now let's say that we've determined that probate's necessary, right? So now you're going to go meet with your prospective client. I always like to ask, a couple questions first. So I first want to ask, did the person have a will, right? So if a person had a will, let's say that you're speaking with Sarah, and Sarah's the only daughter, and she says, yeah, I'm going to get the property. My dad said I could get it. But Sarah's dad had a will and named somebody else as receiving the property. Well, Sarah's out of luck. So you would be wasting your time speaking with Sarah. So you always want to ask. I encourage, it's good habit. Again, you as a realtor, I don't encourage you to determine whether or not it's a valid will or anything like that, but just look at it, or get it when you're making the introduction to an attorney. If they don't have one, say yes, they have a will. So find out if there was a will, and make sure that the person that you're speaking to is actually going to, 1, be the PR, and or 2, going to receive it, that the property is actually getting left to them. If they say they have a will, you also want to ask if they can get a copy of it, or if they have a copy of it. Do they have the original or a copy? We can use a copy, but the original is better. And the reason is wills are not recorded. So if someone dies, and let's say, let's say I do a will right now. I have my will. I put it back here, put it over here, and I just leave it there. When I die, if nobody knows that will is back there, no one's going to know anything about it. Wills are not recorded. There's no, they're not kept with the courts or anything like that generally. So, I've had clients come to me and say, hey, listen, I think my dad had a will. I just can't find it. Can you find it for me? Unfortunately, I can't. I don't really have, you'd want to maybe find out if the attorney, if you know the attorney who drafted it originally, try to do some digging, see if they have it in a safe place. Hopefully not in a safety deposit box, because that could be a little bit difficult getting into now that they've passed away. But wills are not recorded. So we want to ask them if they have a copy of it. Next, we want to ask them what was the relationship to the person who passed away, right? So was this their mother? Was this their father? Was this their cousin? Who was it? And the reason is, if a person dies without a will, all right, and they don't have a trust, because now we're doing the probate process, in Florida, there's a hierarchy of who's going to get a person's stuff. So if a person dies, first it's going to be their surviving spouse, then it's going to be their children, then it's their parents, then their brothers and sisters, and on, until you get out to second, third cousins, right? But before you get to, let's say before you even get to an aunt or an uncle, you've got to go through a lot of people beforehand. So again, if you're speaking with, a brother, the brother of the person who passed away. And let's say that John died and he had a couple children, but they moved to California many years ago and they didn't have anything to do with their dad. But their brother, John's brother, was very close with him, took care of him while he was sick and all of that. Unfortunately for the brother, the children are still going to receive anything that John had because they're next in line to receive something. Now, if there was a will, that's a different story. But if there's no will, again, Florida law has a hierarchy of who's going to receive stuff. And so the closer that they are in relationship to the person who passed away, the more likely they're actually going to receive something and possibly be PR. But again, if you're speaking with a cousin, or even an aunt or uncle, second cousin, that sort of thing, be careful because you might be wasting your time. We'd have to do a little bit more digging to see if there's any other family member. And a lot of times people will say, oh yeah, no, I'm his only family. And they might mean, yes, I'm the one who stuck around, but there might be, unfortunately I've seen situations where there were children who abandoned their parents or had mental health, addiction issues, whatever, and just aren't around, and they still might be entitled to something. So ask, what was your relationship to the person who passed away? So let's now say, that we've determined probate's necessary, we're speaking with the right person, right? And remember, very important, that the person becomes the personal representative once the court says they are. Okay, and so we've determined now that the court is going to likely choose this person that you want to work with, right? They're probably going to have, some of the most common questions that you're going to get asked is, how long does this probate process take, right? So that's a very common question that we get. I'm going to give you two situations. The first is, when did the person pass away, right? So did the person die within 2 years or more than 2 years ago? We're in 2020 right now. If the person died more than 2 years ago, so let's say the person died in 2017 and we're starting the probate in 2020. On average, it takes about 30 days from the date that we get the case filed for the court to name the PR. So about 30 days on average. After that has happened, you, the realtor, are now able to list the property, market the property, and do all that sort of stuff, try to get the property sold after the PR has been appointed. So technically, if we start the probate and the person had died more than 2 years ago, you can probably start the probate, we can probably do this probate in about 3 months. Maybe a little bit sooner, but I say it's about a 2 to 3 month process, more or less, if the person died more than 2 years ago. If the person died more recently, so if the person died, we're in 2020 and they died in 2019, it's going to be a little bit longer. So we open the probate. It takes 30 days to get the personal representative appointed, okay? Then we have to wait a mandatory 90-day period, right? So in Florida, there's what's called a notice to creditor period where we have to wait 90 days. During that 90 days, it's an opportunity for Visa, Baptist Health, Home Depot, whoever that the person might have owed money to, where they're going to come and tell me, the attorney, hey, this person died and owed us, $10,000 or whatever it is. We can't generally transfer any property, sell any property, do anything during that 90-day period. So the probate is going to be a little bit longer if the person died more recently. I generally say it's about a 6 to now 7 month process, more or less. It's about a 6 to 7 month process if the person died more recently within 2 years. Now, I don't have time to get into that creditor period. Feel free to reach out or come to a live event, and I'll talk a little bit more about that. But there's some things you should know about that. But unfortunately, during that 90-day period, we can't do anything, which is why the process takes a little bit longer, right? When you're signing, I guess, last little piece here as we're about to wind up. When you're signing that listing agreement, when you're signing that contract, it needs to be signed by the personal representative. So it shouldn't be signed and really can't be signed by anybody individually. And I talk a little bit more about this in my live course, but once the personal representative is appointed, at that point he or she can sign the as-is contract, and it's going to state their name as the personal representative. So let's say the person's name is Sarah Gonzalez and Jose Gonzalez passed away, her father. So she would sign it, Sarah Gonzalez as personal representative of the estate of Jose Gonzalez. All right, so it's a very long, Sarah Gonzalez as personal representative of the estate of Jose Gonzalez. And so anytime she's signing anything, she's got to sign it as the personal representative. That's kind of the nuts and bolts of the probate process, length of time, what you all need to do. Obviously, there's a lot more that I could share with you, but that's kind of a very, I think enough for you all to know and feel pretty relatively confident when you're speaking with some of your prospective clients and explaining the process or whatnot. Marketing for probate. So probate, again, we're seeing a lot more on the market right now. My recommendation is you can certainly network with other probate attorneys because every probate that, for example, that my office handles or that most probate attorneys handles has a piece of real estate, and so we're always looking to refer that out to other realtors. So get to know your different probate attorneys in your area. You can also buy lists. So everything that we file for these cases, these probates, is public record. So you're going to get the attorney's name and you're going to get the personal representative's name and address and all of that. You could reach out directly to them, to either the personal representative or to the attorney. I always say, listen, this is a sensitive topic. Someone's just died, so your normal, hey, we have cash buyers thing might not be the best approach. Have a little sympathy, a little empathy, come at it from a different approach. But you can buy that information, or that information is public record. Those are probably the best ways. Again, I think really what will happen is you'll just at some point come across a probate listing or someone or on the buyer side. I'm happy to give you guys more advice, more suggestions. Happy to speak with you again. It would encourage you to come to one of our courses that I teach. I also come to the brokerages, so if you're interested in having me come to your brokerage, happy to do that as well. Again, my name, Justin Stivers, owner of the Probate Law Firm, www.probatefirm.com. My email is justin@probatefirm.com, and our phone number is 305-456-3255. Hope you guys found this useful, and again, happy to answer any other questions you guys have. Talk to you soon.